Welcome, everyone. My name is Howard Gould. I'm co-chair of the real estate section for the Beverly Hills Bar, and it's a pleasure to welcome everyone today. We're very excited about today's program, and I've known our speaker now for, I don't know, probably a decade or two. It's quite a while. Um, Before we begin, let me tell you what some of our upcoming programs are going to be. February 26th, we're going to have a program on real property taxes. Chris O'Neill from the Greenberg Traurig firm is coming back to join us along with one of his partners to talk about real property taxes in California. March 19th is our annual California Association of Realtors, that's CAR, update on their new forms or form updates. And Jana Gardner is joining us again, and she is always extremely well versed in what's going on at CAR and the CAR forms. And it's always a very useful program for anyone who does anything in residential real estate in California. April 16th, Howard Fisher, a longtime participant and officer at the bar here, is going to do a program on 1031 exchanges. Larry Jacobson on April 23rd is going to do his annual review of prior years' real estate cases. And we're going to put on a program we haven't done before on May 21st, which is landlord insurance coverage for habitability claims in landlord-tenant disputes, which has become a big issue for landlords as to when their insurance will actually cover them for all the habitability issues that come up. And Steve Raucher, also a former president of the Bar Association, is going to put on that program. There is the link for the program materials in the chat if you didn't get those before, so you can go to the chat and pick up the link. Otherwise, the chat is just for announcements. If you want to do questions for the speaker, please put those in the Q&A. I'll be monitoring those, and we will certainly cover as many of them as we can. So again, it's a great pleasure to welcome Heather Rosing to join us. Heather has a very distinguished background despite how young she is. She's a partner of Rosing, Pott and Strobine in San Diego. She serves as the leader of their complex litigation and professional liability department, and also the discipline defense, ethics, and risk management department. Heather's a certified specialist in legal malpractice law with a nationwide reputation as a skilled litigator in complex and multi-party matters, particularly those involving issues of fraud, breach of fiduciary duty, professional negligence, malicious prosecution, civil conspiracy, excuse me for a moment, RICO, and aiding and abetting. She also practices in the area of administrative law,
Jonathan.
Representing a myriad of professionals before disciplinary agencies, including attorneys in proceedings with the State Bar of California and judges and commissioners in proceedings with the Commission on Judicial Performance. In addition to her litigation practice, Ms. Rosing serves as a risk manager, providing advice to hundreds of law firms, legally related organizations, directors and officers, professional fiduciaries, accountants, and other professionals in areas of ethics, conflict of interest, disqualification, duties to third parties, unauthorized practice of law, and many other areas, including professional responsibility. She serves as an expert witness in these areas as well as on issues of law firm management. Of particular note, Heather served for 4 years on the State Bar of California's Board of Trustees, Vice President, Treasurer, and other offices there. And then in 2018 to 2019, when the California Lawyers Association, CLA, split off from the State Bar, Heather served as the inaugural president of CLA, the largest statewide voluntary bar association in the country, helping them establish themselves as an independent organization. She's also served on numerous ABA committees related to her areas of practice. Heather's a recipient of numerous accolades, too numerous for me to mention here, but has had, as I said, a very distinguished career already. She was born in Chicago, attended University of Illinois and Northwestern Law School, where she served as president of the Student Bar Association. Heather, the floor is yours. Thank you for coming.
Thank you, Howard. I really appreciate that nice introduction. It's very nice to be here
Oh, Heather, it looks like your video cut out actually.
My video cut out.
I hear you now.
Yeah.
You're
Yeah, it
back.
looks like we're back.
Okay, excellent. Sorry about that. I'm Heather Rosing. It's great to be here today. I wanted to thank Howard for that kind introduction, and we have known each other a long time. It's my pleasure to be presenting to the Beverly Hills Bar Association Real Estate section today. I've had the opportunity to present to some of your colleagues through the Trust and Estate section, and I thank you for having me here. So today we're going to go through a very kind of rapid, practical tip session where I've put together a number of topics that I think would be of interest to you as lawyers and as real estate professionals. And we're not going to, dwell on the, intricacies of every rule for these 8 topics, but rather we're going to hopefully impart on you some really, really practical advice that can help you in governing risk in your practice. Governing risk in the practice of law has never been more important. The risk has never been more. I've been representing lawyers for 30 years this year, 2026. So by the end of this year, I'll be a 30-year practitioner because I was barred in 1996. So I've worked with thousands of law firms, thousands of lawyers, and I've seen every possible scenario you can think of in the risk management context, the state bar discipline defense context, the arbitration context, the litigation context. So much of what I impart to you comes from those real life experiences. This is a PowerPoint that I put together on my own. I've shared derivations of it with other groups, and hopefully you find it interesting and informative. As I mentioned in the chat, if you have a follow-up question that can't be dealt with during the course of this program, feel free to email me, and I'm happy to talk with you offline. I find that 1 or 2 people like to do that, and I'm happy to get to know people and to share my impression of the answer to your question. So with that, let's go to our first topic, which is client intake. Oh, well, first, I forgot I have an alert. I put this alert here because it's so important. It's before our first topic. So because we are state bar discipline defense attorneys and state bar compliance attorneys here at Rosing, Pot and Strobing, we do a lot of other things as well, but we have a whole department dedicated to that. We are very attuned to upcoming deadlines. And every year, usually in about the late spring or summer, we get a whole series of calls of people who are panicked because they've been put into administrative inactive status on their state bar profile. And they usually learn that because a client or their opposing counsel have told them that their state bar profile says they are on an administrative inactive status. Then they have to figure out whether they engaged in the unauthorized practice of law, and it's a true nightmare. So I am putting this out there because the state bar has these following compliance points that are on this slide. And the compliance needs to be done by certain deadlines. And the general, what they call timely compliance deadline is March 30th, 2026. You then have some latitude to complete these items after that, but best practice is to have it done by March 30th, 2026. So I just wanted to quickly touch on these with you. This is an actual screenshot of what you see when you log into your State Bar profile. So, log in today is my recommendation. This is my own profile. I screenshotted for you so you can see I still have to complete these items. But number 1 is the annual fees. Number 2 is civility oath. You are now required to take an annual civility oath pursuant to the rules of court. I was the co-vice chair of the statewide civility task force, and this is something we got passed because of our belief in the importance of civility in the profession. CTAP annual reporting, we're going to talk about that a little bit later, but this is your trust accounting reporting. It's probably the most sticky and difficult requirement out of all these requirements, and it needs to be completed by you personally because you need to attest to the answers under penalty of perjury. MCLE, that's why you're here today, getting ethics credit. Another important requirement, keep in mind that MCLE compliance just requires you to say that you did comply, but the State Bar does audit. And if they audit, then you need to transmit the actual CLE record showing that your compliance certification was truthful. There's a pro bono annual reporting requirement and an attorney record verification. I actually had a client who was put into inactive status, and I'm not sure if that was a mistake because it was kind of new at the time, but because she didn't comply with the attorney record verification, which you would think would not be something that would have that type of repercussion, and maybe it doesn't anymore. But these are the requirements. Once they're completed, all these boxes or circles turn green and it says completed. Next slide. Okay, now we're on client intake. Now that I've sufficiently scared you about the compliance tracker on your StateBar profile, we'll get into client intake. And next slide. So these are the practical considerations that I promised to bring to your attention. Again, I look at these rules from the perspective of people who have called me with their problems, lawyers who have called me with their problems. And I get many, many, many calls regarding what we call 1.18 potential client scenarios. Keep in mind that if you are taking calls from potential clients, you may be incurring a duty of confidentiality to those people. And if you incur a duty of confidentiality to a potential client, then you may later be disqualified from being adverse to that client in the same or a substantially related matter. Family law attorneys fall into this trap all the time. But my advice to you is when you're talking to a potential client, don't accept more information than is necessary to figure out whether that person is a good fit. If you really start getting into it and you spend an hour on the phone with them and you accept confidential information, you will want to enter them into your conflict system in order to make sure that you are not later adverse to them, even if they do not hire you. Potential client situations lead to a lot of disqualification motions. We'll talk about that a little bit later. The other thing, of course, is when a potential client comes in, you want to make sure that you've run that conflict check before you're talking to that person to make sure that you can actually potentially represent them. Sometimes I make the mistake of getting too excited about talking to a lawyer and I forget to run the conflict check. I do that very rarely, but it's a mistake. The one category that I would mention to you here is the fit check. This is what we call it here at Rosing, Pott and Strobing. And this is where you should, figure out from a preliminary standpoint if the client is the right client for your firm. In the, 1,000+ malpractice cases that I've handled, I will tell you that I have heard this hundreds of times, what I'm about to tell you. Heather, I did make a mistake. And my mistake was I should have gone with my gut at the client intake stage and turned down this client who has just sued me for malpractice. Or I should have asked more questions to ascertain that this person wasn't a good fit or this company wasn't a good fit for my law firm. So fit check, practice area, do they fall squarely within your practice area? Does your workload permit it? Does the client have the finances in order to support your services? As you can imagine, this is one of the key points of dispute and tension between lawyers and law firms. You probably encountered it yourself. I would be surprised if you haven't. But if the client can't afford you, it's going to go wrong, and it's going to go wrong in the middle of the representation, leading you to a situation where you may need to withdraw and the client potentially making allegations at that point in time. And do you get along with the potential client? Sometimes you can feel like it's not going to be a good personality fit. The red flags, I did want to mention, these are the ones that come up, and these are the ones that later shine out in the malpractice case that we are defending. Did that person have 3 lawyers prior to you? Did they pay those lawyers? Did you ask for docs, or are you asking for docs during this intake stage and they're not providing you with the docs or the information? Do you feel like they're being cagey with you? Do they have realistic expectations? Do they expect the transaction to close for 20 million when it can only close for 10 million? Do they expect to get a $50 million recovery in litigation when the case is really only worth $500,000? And are they responsive to you? I will tell you, even if you do accept the client, but you later experience these red flags, do consider whether or not you want to continue on with that representation. The next slide, please.
Heather, the one other thing that troubles me sometimes is when you have a client and you can see they're going to want you to take a position that you're not going to be comfortable with for whatever reason.
That's a great question. Is my audio okay at this point? I just want to double check.
Yes, we're all great.
I'm hearing
Great,
you now.
excellent. Okay. Howard asked a great question, which is, and sorry, there seems to be like a little bit of a glitchy freeze thing going on, which we talked about in advance, and I'm not sure what's causing that. But please do let me know if there's any problem with anyone hearing me, and we will make sure that we remedy that. I'm sorry, could you repeat the question one more time?
What I was saying? Yeah,
Yeah.
the point I was making is just that sometimes I find another big red flag is when you can see that a client is going to want you to take a position on their behalf that you're really uncomfortable with for whatever reason.
Yeah, that's a great one, Howard. I really appreciate you mentioning that. And in fact, as a lawyer, you can't take a position without probable cause. You can't take a position for the purpose of harassing somebody. So I think that if the client says, hey, this is the strategy I'm looking for from a lawyer, and the strategy is not something you think is right or ethical, or you're just not comfortable with, that's a great reason for declination. I don't think you'll ever, as a lawyer, regret a declination. That's my opinion,
I
having.
had a partner who took on a life insurance claim on behalf of someone who was accused of killing his wife and his child, and that was the policy, of course, that was at issue in the case.
Wow. Yeah, well, there you go. That's a very illustrative story and it nails down the point. So thank you for that. Um, okay, so topic number 2 is diligence. The rules of professional conduct were revised in 2018, November 1st, 2018, they came into effect. I was a legal advisor to the Rules Revision Commission of the State Bar. We made the proposals. Most were adopted by the State Bar, and we implemented a new diligence rule, 1.3. There was no diligence rule before then in the RPCs, though the standard has been around for a very long time. So this is an ethical standard, not a malpractice standard, though it could lead to malpractice claims. But reasonable diligence means that you have to act with the commitment and dedication to the interests of the client, and you do not unduly delay the matter entrusted to you. So diligence is kind of a wide-ranging concept that ties in heavily to the uh, the other ethical obligation of competence, but it has some nuances to it. And in particular, here I want to talk about how diligence ties into deadlines. We're a very deadline-oriented profession. I don't know about you guys, but I use the word calendaring like 5 times a day minimum, probably more than 5 times a day. But if you use the word like calendaring with a normal person in life, they don't understand why you keep saying the word calendaring because it's not a word that they utilize unless they're in a business with a lot of calendaring. But very few people calendar like we do as lawyers. But I will say this, I am finding that as the practice of law is becoming more pressure filled, with more and more requirements, with more difficult clients, with more laws that come out on an annual basis and sometimes more frequently than that. Lawyers are having harder and harder time meeting deadlines. My I guess, admonition to you here is that it's important not only to meet deadlines, but to get ahead of deadlines, not only from an RPC standpoint, but from a malpractice standpoint. If you are an IP practitioner, which you probably aren't, because you're here on the real estate section, CLE, IP practitioners experience catastrophic claims by failure to meet deadlines, sometimes due to lack of calendaring, but sometimes due to a lack of paying attention to the calendar. For example, paying a fee associated with a trademark or a patent. We've seen those claims in the hundreds of millions of dollars, so you can see the import of it. But what I would say here is that lawyers who wait to the last minute oftentimes will miss the deadline, will do shoddy work, and I've seen this play out before the state bar and in malpractice cases, and it is not pretty. The practical tip that I give people is don't be afraid to ask for help if deadline management becomes difficult, especially if you're an associate on this call, one of the 54 people, or somebody who's not senior management. Go to your senior manager and just say, hey, I appreciate the workload. I'm still learning how to manage it, and I need help with these deadlines. I need help managing these deadlines. I'm not sure I can make all of these deadlines. It's hard to say. It's hard to admit that. But if you try to do it all yourself, you're going to fall into traps. And I'll tell you the trap that people are falling into with last minute deadlines. Can anybody guess what it is? I don't think I can hear you, so maybe you can't guess. But AI. People are running up against deadlines and they're generating AI work product, submitting it to the court, submitting it to the client, submitting it to opposing counsel. And in fact, as we will talk about later, that comes with its own perils. So going to the next one, tip number 3. Fee agreements. Okay, next slide. Fee agreements are critical. I've edited and drafted thousands of them, not only for myself and my law firm, but for our clients, because our clients have specialized practices and they need specialized fee agreements. So sometimes we work on certain clauses, sometimes we draft the whole thing for them, but your fee agreement needs to be something that you review on an annual basis. I would calendar it for an annual review. Make sure that you like the terms, that they're working well for you. The first thing I would mention is that your fee agreement needs to be reviewed by an attorney before it goes out. Paralegals and legal assistants should not be issuing fee agreements without
The
your
audio
approval.
has cut out.
It's funny because I can see myself and but no.
Now we're hearing you.
Okay, thank you. Um, uh, what I was mentioning here is that you as an attorney need to review the fee agreements and approve them before they go out, because there's a number of provisions which cannot be handled by a paralegal or a legal assistant. For example, the scope of representation. Your fee agreement needs to be clear on what it is you are doing and what it is you are not doing. The fee agreements that have a scope that is undefined or too broad oftentimes will lead to confusion and will lead to missed deadlines, will lead to the client believing that you are doing more for the client than you are actually doing. There's a famous published opinion out there about a workers' compensation attorney who is handling a workers' compensation case. And the personal injury statute of limitations against a third party expired during the workers' compensation case. And the workers' comp attorney was sued. And he said, no, I was just the workers' comp attorney. But the fee agreement didn't make it clear that the representation was only limited to that and excluded the personal injury defense. And in fact, what ultimately, in kind of form and fashion, the court found is that that attorney had the right under the rules of professional conduct to limit the scope of his services, and he could have excluded the personal injury services, but he didn't do that. So it was therefore at the minimum his ability or his obligation to provide a referral or to advise on the statute. Next slide. So this is the rule that I mentioned a second ago about limiting the scope of representation through informed written consent, Rule 1.2. This is done through your engagement letter. There are a couple of other questions here that I wanted to mention that you should tackle when you're putting your engagement documentation together. Who is it you represent and who do you not represent? For example, let's say you represent an LLC. I know that's a very common thing in real estate practice that you would represent an LLC. Do you represent any of the individual members? Do you disclaim representation of the individual members? Many lawsuits come out of LLC members or come from LLC members who claim individual representation of themselves in addition to the representation of the LLC by the attorney. And the attorney says, no, that's not the case. Oftentimes we go to the LLC operating agreement to try to clear that up, but it could have been cleared up through the fee agreement. I hope this highlights the importance of your involvement in the scope section of your engagement documentation. Next slide. And just on fee agreements as well. I have like a 2-hour presentation on fee agreements, but other slides or other provisions that you'll want to take a look at as you proceed, just so you have them in your mind, is your arbitration provision. If you want an arbitration provision, do not have a prevailing party attorney's fees clause. Bad idea. Run back to your desk after this presentation and delete it from all your fee agreements. You need to take a look at things like third-party payor agreements, which also would be in your fee agreement. A lot of people are including conflict waivers, which need to be customized in their fee agreements. Some people are doing litigation holds now in their fee agreements. These are all things that you can consider if you think that they are right for you, but put your time into it. So topic number 4, conflicts of
Excuse me,
interest.
Heather, but one
Yeah.
really tricky thing to keep in mind is a lot of times you're hired by another lawyer or you're representing more than one person, and you always, if that's the case, if it's not a single individual, want to include who you can take instructions from and who you're authorized to act on direction from. I had to do that this week where I'm being retained through a lawyer. I've never talked to the client who's out of the country. His main contact is his family law lawyer, and I'm only handling the real estate aspects. And so I had to put in something specifically about taking instructions from that lawyer.
Yeah, I love that, Howard. Thank you so much for that great tip. And the conflict of interest section of your fee agreement, which needs to be customized, it can talk about all those concepts. If you're representing joint clients, it can waive the conflicts between joint clients. It can say who you're going to take instructions from. It can say, who is responsible for the payment, who gets for example, a refund of any payment, which client. It can also do things like, authorize certain agents to receive information, so you're not breaching your duty of confidentiality by sharing information with agents of your clients. So thank you for that, and that's a good thing to think about. Topic number 4, conflicts of interest, basics and trends. This is definitely like a 10-hour course, but conflicts of interest come up all the time in state bar proceedings and in breach of fiduciary duty lawsuits. I see it being weaponized, like, there's not really like a serious conflict consideration that we think actually impacted anybody. But because it's conflict waivers need to be so specific, attorneys trip up on the requirements of conflict waivers all the time, putting them in peril later on of a breach of fiduciary duty claim. So next slide. So here I just wanted to give you a sense of the top conflict of interest rules. We're not going to be able to go through all of these. I've picked like 3 of them to talk about, but there are quite a few of them. So you can take a look at this list over a glass of wine tonight. So we'll go to the first example, the next slide. Current clients. So this is, these are the 1.7 A and B are, I think, the 2 most common conflict scenarios that arise. I mean, I must cite 1.7 A and B also, 5 times a day right after I use the word calendaring. So this is really important for everybody to focus on. 1.7A is just a very basic premise, which is you can never be adverse to a current client, even in an unrelated matter, period, because you have a duty of loyalty to them. Duty of loyalty is one of your 2 fiduciary duties, the other being the duty of confidentiality. You can't be adverse to a current client, even on an unrelated matter. Ethical walls don't work. Subsection B deals with other, well, you can if they give you informed written consent, but nobody gives informed written consent, candidly, in these situations. Informed written consent, by the way, is a conflict waiver, that they mean the same thing. And in a couple of minutes, I'll tell you what would need to be in your informed written consent in the event that you get a conflict waiver in any of the conflict scenarios that we're presenting today. But subsection B also comes up all the time. And subsection B deals with different conflict scenarios, and I'll tell you what those are in a second. Those also can be waived with informed written consent. But subsection B deals with certain conflict scenarios that present a significant risk of material limitation in your services. And what are those scenarios? It's significant risk of a material limitation based on your responsibilities or relationships with another client. The classic situation would be joint client scenarios. Can you represent both clients at once? If representing them both at once presents a significant risk of a material limitation, then you can't do it without a conflict waiver. The next one is a significant risk of a material limitation posed by a former client or a third person. Maybe you have a relationship with a witness or the former client is involved in the case somehow, and that handcuffs you. You shouldn't be disadvantaging the client, the current client, in that scenario without getting a conflict waiver from them, informed written consent to proceed. And finally, if there is a significant risk of a material limitation by your own interests, a classic scenario there is if you make an error. Let's say you miss the statute of limitations and you're trying to fix it. So now your own interests are implicated. Should you be representing that client without a conflict waiver in place? Rule 1.7B says no. So I wish I had more time to go over these because they're so important, but these are the top conflict rules that you will likely encounter in your practice. Next one. Because you are real estate lawyers, I figure there must be situations from time to time in which you yourself enter into business transactions with clients. Maybe you're involved in the deal. That's permissible. 1.8.1 details the type of conflict waiver you need in these scenarios. This comes up more often than you would think. And a lot of lawyers miss it because they do things that they don't realize are a business transaction with a client. I had years ago these clients who were T&E lawyers and they went to the restaurant business with their client and they didn't get a conflict waiver. And they're like, we needed a conflict waiver for that. It had nothing to do with our representation, but it doesn't matter if it has anything to do with the representation. It's still a conflict if you have a current client relationship. But essentially, you can do it, assuming that you have this conflict waiver, informed written consent, and you advise the client to seek independent counsel, and the terms are fair and reasonable to the client. I would say that the prudent lawyer who is actually taking a cut of the deal, maybe as payment, will require that their client have this conflict waiver reviewed by separate and independent counsel before the client signs. That's a hot tip from me, which will be highly protective in the event that this is later called into question. Next slide. I did want to mention third-party PORs because lawyers miss this conflict, point all the time. 1.8.6 is a conflict rule, and it requires the written consent of the client in the event that you are accepting fees from a third party. So let's say, for example, you're representing a company and the company is defending an individual. You should be getting that individual's consent to take money from the company for the representation. That's because, theoretically, the person who's paying could have some type of influence over you. So the client is entitled to know and consent to a third party paying the fee. As I very obliquely and quickly referenced earlier, prudent retainer documentation also indicates who will receive any refunds of an advance fee at the end of the case. I get this call once every 2 months. Who do I give the money back to, the client or the third party payor? And I always say it would have been great to have set that forth in the initial engagement documentation so there's no confusion at the end. Next slide. And Howard, please keep jumping in with your great tips. I did want to briefly mention, as I referenced before, disqualification trends. We are, I keep, mentioning, things that are happening with frequency in our practice. But one of the things that's definitely happening with more and more frequency is threats of disqualification. We're involved at any point in time, probably in 6 or 7 disqualification scenarios with clients. Sometimes we're counsel for them, sometimes we're behind the scenes. But these are 3 things that I'm finding are giving rise to many disqualification allegations and motions. Number 1 is lateral hiring. If you do not have a refined lateral hiring conflict check procedure and protocols, you need to put one in place. More and more law firms are hiring laterals, not doing adequate conflict checks, and 6 months later, they're getting letters. The law firms are getting letters saying, hey, this lateral you hired is conflicted, and now your law firm needs to get off the case. Keep in mind that in lateral hiring scenarios, ethical walls are usually not curative. People think they are, but they're not. These are 1.9 and 1.10 scenarios. Those are the rules of professional conduct. I don't have time to give the lateral hiring, rundown right here and now, but hopefully this puts it on your radar screen that lateral hiring scenarios need to be dealt with at the outset through a full conflict check before the lateral hire joins your office. Potential client consultations, I mentioned that before. If you accept too much confidential information, you could be disqualified from being adverse to that potential client who never hired you later on, even years later. And next is inadvertent disclosure. This is a big one where lawyers will get inadvertently produced information and they don't go through the protocols of 4.4, which is based on the Supreme Court of Rico v. Mitsubishi, which requires prompt notification, segregating the inadvertent disclosure or inadvertent production. And as a result, they are subject to disqualification. So keep your eye out for these 3 things because motions to disqualify are not pleasant. Next slide. Okay, I mentioned that I would tell you what informed written consent is. Again, this is just another name for a conflict waiver. It is the verbiage used in the rules of professional conduct. Because I'm running a little bit behind, I'm just going to mention the second one to you. A conflict waiver, i.e. informed written consent, cannot be a stock form. And the reason it can't be is, number 1, a conflict waiver could deal with, a dozen different conflict scenarios, but it also isn't effective under the rules of professional conduct unless it essentially discloses the cons or the downsides of waiving that conflict. So the client needs to be completely informed as to the potential conflict or the circumstances that give rise to the need for informed written consent. And what does it mean for the client to waive it? I'll just give you a quick example. Let's say it's a joint representation conflict waiver. It would say, we represent both of you in the case, and here's what the case is about. And your position seems aligned at this time, but that could change. You could take differing positions on settlement, or you could have different recollections of the key transaction, or you may want to try to give us differing instructions, or maybe one of you tries to make an indemnity claim against the other. So these things could come up, and you know they could come up, but nevertheless, at this time, you waive the conflict and you agree to our joint representation of both of you, and you have had the opportunity to consult with independent counsel. The conflict waiver with that detail is going to be enforceable and found to be adequate under the rules of professional conduct. A stock form that does not have the details specific to that situation is not. Going to the next slide. Oh, and by the way, my least favorite thing is when we handle breach of fiduciary duty cases and we get the conflict waiver, it's in the file and nobody's signed it. Like the lawyer took the time to draft it, but nobody followed up to get the signatures. So that's very painful, very painful. Okay, client satisfaction, proactive management. We are finding that more and more state bar complaints in particular, state bar gets, I think, around 18 to 20,000 complaints a year. It's a lot, but more and more of them are just based on clients not being satisfied, sometimes just vaguely not satisfied with the service that they received. Sometimes they think the fees are too high. Sometimes they have a specific result that they're complaining about. But a lot of times it's just about communication. Going to the next slide. So I wanted to mention here just some practical guidance tips in terms of client satisfaction, including this communication point. I did want to say, take a look at Rule 1.4, which has a correlated statutory provision in the Business and Professions Code. The rules of professional conduct need to be read hand in hand with the State Bar Act, which is found in the Business and Professions Code. Those are the legislatively enacted provisions that govern the practice of law. But what these rules collectively indicate is that you are supposed to reasonably consult with the client about the means by which to accomplish the objectives of representation. Make sure you do that. Then you're going to be proactive in managing that relationship from the bat. Figure out what the client wants, and then tell the client how you intend to achieve it. As Howard said, if they want something you can't achieve, then turn them down. Keep the client informed of significant developments and comply with their requests for information if it's reasonable. That is a term of art in the ethics rules, significant developments. You're required to tell clients about significant developments. And this includes, of course, as all of you know, a written settlement offers, but frankly, any settlement offer. Oftentimes malpractice cases come out of a purported failure of the lawyer to disclose settlement discussions, even if it wasn't an offer. The lack of communication can breed client discontent. I've seen so many great lawyers that are like doing their thing and they're doing a great job, but they are not communicative with the client, and the whole relationship blows up. And you kind of wonder, how did it happen? The lawyer was doing a good job, but the communication wasn't there. Final point is we do recommend emails. People say, Heather, isn't this CYA? I don't have time for CYA, but it's really not CYA. If you're talking to a client about complex legal matters and complex decision-making points, keep in mind that they may not track you entirely over the phone. They may not track you in the in-person meeting, maybe a little bit, but maybe not 100% because they're not lawyers. Put it in writing, lay out the decision-making points, lay out the risks, lay out the pros, lay out the cons so that they can go back, take a look, and make an informed decision. Particularly information regarding risks, put it in writing. A common one is going to trial. A lot of people will lose their trials, and sometimes they'll be hit with a prevailing party attorney's fees motion. It's very common for them to claim, I didn't know that I could lose this trial. I did not know that I could get hit with prevailing party attorney's fees. It's obvious to us and our client that was discussed throughout the representation, but we don't have a clear warning email on that particular topic. The same would hold true with regard to a real estate transaction. I understand that many of your clients are probably pretty sophisticated, and it is true. If the client is sophisticated, this becomes less important to put the risks in writing. But nevertheless, even the most sophisticated of clients will, at the minimum, appreciate your efforts to update them in writing and remind them of the things that they need to take into consideration in their decision-making calculus. Next slide.
Heather,
Yeah.
I don't know if you think this one is useful, but I have put for a long time in my fee agreements to the client that the billing statements are communications to them about activity or lack of activity in their cases, and that they need to read those because they are communications about what's happening in their case.
I love that. I think that's great. It shows it makes them look at what you're doing, right? it also makes them examine the bill, because then if the bill is too high and they don't say anything, then then presumably they're okay with the bill. Or if they think the bill is problematic, they have the chance to say something. It's a great idea, Howard.
And the bills say that they have X number of days to challenge the bill as well. So yeah, it's if you aren't sending status reports, it is maybe in some ways to help make up for that.
Yeah, I love it. It's a really good. I see a lot of people do that with tell us in 30 days if you don't like a billing entry, but telling them to review it to make sure they know what activity is taking place. I don't see that as often in engagement documentation, and I like it. So this is practical guidance in terms of this proactive communication and proactive management of the client relationship. We covered a lot of this, but I would just hit on two final things. Periodic check-in calls or meetings, even if you don't have a burning urgent decision-making point, every 2 months, just offer a call to talk to the client about what's going on. And the other thing I would indicate to you that's quite important is clear written communication regarding the end of representation. This sounds a little self-interested for our profession, I get it, but the statute of limitations usually does run on malpractice claims 1 year after the end of representation. And so it's a good idea to end your representation if it's over in writing. Dear Bob, thank you so much for the opportunity to help you with this transaction. The transaction is complete. Our representation is concluded. If we can help you in the future, please call anytime. And again, that is not just for the lawyer and to get the statute running. It's really a courtesy to the client. The client now knows that the client doesn't have a lawyer because the legal matter for which the lawyer was retained is included. That's a fair thing for a lawyer to tell a client. If the client disagrees and thinks that there are still outstanding items, the client can then go ahead and bring those up with the lawyer. Next slide. Okay. Okay, this is the big one, CTAP, CTA and CTAP standards. CTAP, in case you don't know, it's the Client Trust Accounting Protection Program. It went into effect essentially in 2003 after the Girardi scandals. It's a whole program with many, many facets. As you will see in another slide, I refer you to the State Bar website. They have a whole CTAP webpage. It has videos, it has hypotheticals, it has FAQs. It has the rules. It's pretty good. It's very good, actually. It also has the new auditing standards and programs. So that's one I'm sure you're going to want to rush and read this evening or tomorrow night, again, over happy hour. So let's go to the next one, and I'll give you a couple more specifics on this exciting topic. Okay. So after the Girardi scandal, CTAP went into place, and as part of that, Rule of Professional Conduct 1.15 was modified. If you don't know this, you need to know this. This is client trust accounting. If you have a client trust account and you hold money in your client trust account and you receive funds, you need to notify the people who have an interest in those funds within 14 days and disperse all the funds within 45 days. That's because Mr. Girardi held funds for a very long period of time, and there didn't used to be a date by which funds needed to be distributed set forth in 1.15. It said something like promptly, but now it's 45 days. However, you cannot distribute funds if there's a dispute. For example, let's say there's a lien on the funds. You can't just, at 45 days, just unilaterally decide, the lien dispute yourself and ship off the funds. But you are required at that point in time, while you are holding the funds in trust, to seek prompt resolution of the dispute. I will tell you, because this is a daily practice area for us, there are not great mechanisms for resolving disputes over funds that are held in trust. But a couple of them are here: fee arbitration, private arbitration, mediation, declaratory relief actions, and interpleader. We utilize all these tools. None of them are quick. None of them are great. CTAP. Okay, so CTAP is a program. It has an annual requirement, as we discussed, as you saw on your compliance checker, where you need to enter your client trust account, and then you need to confirm for the past calendar year that it was in compliance essentially with 1.15, as well as the standards set forth in the Client Trust Accounting Handbook published by the State Bar of California. It's like a 40-page handbook with all sorts of very helpful exhibits and addendums. You need to make sure your journal, your ledger, and your bank reconciliations are perfect and whipped into shape, and that it balances. If you can't do this yourself, hire a professional to do it. State Bar ain't messing around. now, just in August, I believe.
Heather,
Yeah.
when you say hire a professional, I mean, if can that be your bookkeeper, or do you really need to have a CPA looking at these things?
It's a good question. I mean, uh, a lot of people do have bookkeepers who do it, but you have to, with your bookkeeper, make sure your bookkeeper is licensed and bonded. I'm sure this is rare, but bookkeepers do embezzle. So make sure your bookkeeper is trusted and bonded, or if they're your employee, make sure that they're vetted. Number two, make sure that they're trained. A lot of bookkeepers, like we have lawyers that come to us, they're like, my bookkeeper does the books. And the bookkeeper has no idea how to do client trust accounting. There's no bank recs, ledger, or journal. It's just like some random bank records. So, yes, you can have the bookkeeper do it if the bookkeeper is properly trained. However, it's a non-delegable duty, so you need to be overlooking and overseeing the bookkeeper. If you are a larger operation, let's say you're a law firm of 50 attorneys, the bookkeeper or even the internal CFO may be inadequate, and you may need an outside accounting firm to assist with the function. There are outside accounting firms that are now holding themselves out as specialists in client trust accounting practice in California. So, really, Howard, it depends on the individual needs of your organization. But the most dangerous thing is the lawyer, usually small firm solo practitioners who just do it totally themselves, right? And that can be a disaster. We've had a number of clients who've been brought up before the state bar, and they're good people. They certainly didn't embezzle any money, but the books weren't in good shape. And they had to hire essentially forensic people to come in and go back and recreate their books for years just to make sure that it was all balanced out. So don't put yourself in that position. It requires weekly maintenance to do a trust account right. The really good law firms are doing daily reconciliations, not formal reconciliations, but daily examinations of their client trust accounts, what's coming in, what's going out, and updating those ledgers and journals on a daily basis. So, you can see how that can get onerous. I did mention that you want to check out the Client Trust Accounting Protection Program page. And then the auditing was the final thing I wanted to mention. They are doing audits now. Back when I was on the State Bar Board of Trustee, I think there were 9 states that did CTA audits, and I was involved in exploring those. I spoke to the people in New Jersey, and they have been doing it for a number of years. And they essentially, and this is what the State Bar of California is doing now, they sign up a bunch of accounting firms. You get randomly selected for the audit. I think they're letting you pick which accounting firm you want at this point. You pay for it, and the accounting firm does an audit. Now, they're not looking to punish you and they're not out to get you. This is mainly an educational process because probably what they're going to find is that your record keeping isn't perfect. And then they're going to try to help you, understand how you can comply going forward. Occasionally, they'll find embezzlement. Occasionally, they will find misappropriation. But hopefully that's not going to occur to too many of our practitioners. I think most lawyers are really good people. I think very few people are misappropriating client funds, but it's a nerve-wracking moment when you get that CTA audit. And I've gotten probably 10 calls from clients who have gotten these audit notices. It's brand new. It's just happening for the first time. So we don't have statistics or anything like that yet. But this is a client protection measure of the State Bar of California. Next one.
And I have one question, Heather, I see here.
Yeah.
If a client instructs you to hold funds in trust pending future work, is it still okay to do so? And should a prevailing party attorney fee clause include only an arbitration provision, including only in an arbitration provision, be removed too? So 2 questions.
What's the second one? Read it. The prevailing party
Yeah,
attorney clause.
let's do the first one. If a client instructs you to hold funds.
Yeah. Well, I mean, if it's an advance fee and the client is instructing you to hold it because additional work may take place in the future, that's generally fine. If the client has a settlement that comes in and the client's like, just hold my settlement for 6 months, I think you need to be careful because there's a bunch of considerations at that point. Number one, you may be required to open up a non-IOTA account, which accrues interest for the benefit of the owner of those funds as opposed to the state bar, because your regular trust account interest goes to the state bar to support the IOTA program. Secondly, it could be considered commingling at some point. I mean, well, that's more if you leave your own entitlement in the client trust account. For example, if a settlement comes in and you don't take your own fee out, that's considered commingling. So I'd be
You,
very reluctant to do that unless it's an advance fee.
you
I
had
guess it would
advi-
depend on the
I'm sorry.
circumstances.
You had advised to take out your prevailing party attorney fee clause.
Yeah.
The second question here, do you say you should do that if it's only in an arbitration provision too?
Yeah. Take it out
Mhm.
immediately. Take it out immediately. It's bad. It's even worse than an arbitration provision in some circumstances. I mean, I could tell you with great certainty, having handled many, many cases, that I've seen it work to the advantage of the lawyer in my whole career twice. I've seen it work against the lawyer hundreds and hundreds and hundreds of times. It encourages malpractice suits, and it's just not going to help you. Take it out immediately. All clauses. My advice, and I think it's good advice. Topic 7, cybersecurity and wire fraud. Okay, we're going to go over this very quickly. We only have 8 minutes left, but I think we can do it. This is a friend of mine who works at Hinshaw and Culbertson gave this picture to me, and he said I could use it. And this is also his pro tip, which he said I could use. More data breaches are the result of human error than hacking. And what people tend to do is they tend to stick their heads in the sand and ignore the possibility of this happening until it's too late. But in fact, data and cybersecurity is everybody's business. We'll go to the next slide. So what I wanted to mention here is that we are seeing lawyers hacked on a regular basis, but we are also the hacking is not, and I'm no hacking expert, but the hacking is not usually happening through some type of mechanism that doesn't involve an element of social engineering. And I've learned a lot about social engineering, and I've tried some cases involving social engineering now, so I've learned a bit about it. And this is essentially, the best example in the law practice is the hacker is sending something to you or to your legal assistant or somebody on your staff that has a link that's going to open up a malicious file, which is going to allow somebody to hack your email. And the email that involves that malicious link um, is socially engineered in such a way that it is designed to make the recipient open it. Sometimes it looks like it's an email from opposing counsel with the document production. Sometimes it looks like some type of urgent personal message. Sometimes it looks like discovery responses from somebody else in the case with a link. I mean, it can look like a million different things, and oftentimes it's hard to know where that malicious link came from in the first place because the actual hack isn't revealed until 6 months later. So we'll go to the next slide. But our general advisement here is in order to prevent the hack into your own computer system and to avoid these social engineering scams and your employees falling prey to them is to engage in proactive training within your law office on what social engineering is, what hacking is, what phishing is, what to open, what not to open. And in fact, there's a bunch of great companies out there that will do tests. They will send emails that have, they're not really malicious links, of course, but they're things that should be spotted as malicious links to your employees, and they see if your employees open them up. So consider that type of thing for your organization. If you're hacked, it's going to be bad, and you're going to wish that you had done this. Next, I wanted to mention as part of this whole cybersecurity and data breach is the CTA scam. This is where lawyers are having anywhere from $200,000 to $18 million. That's the highest one I've seen stolen from their client trust account. Sometimes it's stolen from somebody else's client trust account and you're blamed for it. So that's another derivation of it. But I'm just going to give you this fact scenario really quickly because I've handled 30 of these cases, 40 of these cases. I've tried one of these cases, actually arbitrated one of these cases. So I know the scam very well. So let's say Angie is supposed to pay Bob. He's sharing a great arrangement. Bob falls victim to this phishing scam that I just described. Hacker has full access to Bob's email. Hacker is quietly monitoring Bob's email. Bob has no idea, and he sees that Angie is going to pay Bob. Now the hacker, because he has control of the email, he can send emails from Bob's account. Bob has no idea. Next slide. The hacker, pretending to be Bob, emails Angie and says, "Hey, Angie, wire the money to my bank account. Here's my information, Angie." Angie doesn't call Bob to confirm. She just wires the money. Um, so she wires the money to the fraudster. The fraudster now has the money in his account in Singapore. I just made up Singapore. I'm not sure if that's where the account would really be if you were a top-notch hacker, but it's usually someplace foreign. Bob doesn't even know that this happened. He never even saw the email that the hacker sent to Angie because the hacker deleted it after the hacker sent it. The money is unrecoverable, $200,000. This is not covered by any type of insurance. Even when these transfers involve clients, oftentimes it's excluded through your E&O, errors and omissions policy. The tip I have for you here is if you are engaging in any type of wire transfers, if you're involved in a wire transfer, if you're settling a case or doing a transaction involving a wire transfer, you need to employ triple, double, quadruple security protocols to confirm those wire instructions and confirm that the person who sent the wire instructions is indeed supposed to be the recipient of the funds. We advise Zoom calls where you look the person in the eye, you recognize their face, you know who they are, and you repeat the instructions back and forth to each other verbally. These are really bad scams. The $18 million one, we got the money back, but another one, $3 million, no money was recovered. So many, many tragedies. Next slide. A final topic in our last 3 minutes, AI and the law. I mentioned this at the beginning. It's a super hot topic. You may be a little tired of hearing about it. The topic is progressing so rapidly that I don't have final answers for you, but a couple of hot tips for you. Next slide. I think you know what generative AI is, but I gave you this definition here. Next slide. I did want to mention that one place that you can go for tips and tricks and rules on the use of technology within your ethical obligations is the State Bar website. I think it's very good on this. You can see here that, and you'll see it on the next slide, the State Bar approved a white paper called Practical Guidance for the Use of Generative AI in the Practice of Law. There's a link right there. If we go to the next slide, oh, I'm sorry, the link is at the top. Anyway, take a look at that white paper, take a look at the State Bar resources. Now we can go to the next slide. I would say the key, there's a bazillion rules mentioned in this white paper, but I would say the key one for you to keep in mind is competence. Our law firm has very quickly developed expertise in dealing with the fallout of the improper utilization of AI in the practice of law. And it's usually because of competence issues, not always, but usually where the lawyer who's using the AI just doesn't know how to use it correctly because they're unaware of the risks, they don't understand the tools, and then they fall into this trap, which we'll discuss in the next slide, and ultimately many of them suffer some pretty harsh consequences. Competence is you can't grossly, negligently, or can we go back 1 second? Intention. That's actually going to be an ethical violation. And you can see the comment says this applies to the use of technology. Next slide. Okay, yep, there's oh, that's the white paper. I gave you the link twice. It's so important. Next slide. I have a great slide that summarizes everything. I think it's the next one. Aha, yes, here it is. So here are the emerging issues. This is my final substance. The emerging issues in the realm of AI are as follows. I'm just going to blow through these in my 1 minute left. One of the hot emerging issues is fee arrangements and the reasonableness of fees and the adjustments that you may have to make based on your utilization of AI. For example, let's say you used to review documents for 10 hours, but now AI does it for you in a half hour. You can't bill 10 hours any longer. You can only bill the half hour unless you have a flat fee arrangement with the client. Or let's say you do bill the 10 hours, right? And the client says, aha, how come you didn't use AI to achieve efficiencies for me? This could have been done in 1 hour. Where does that leave you? What efficiencies are you required to achieve through the utilization of AI? It's a big issue. Another issue is client consent and the utilization of engagement letters to get that consent to use AI. Many people are incorporating that into their engagement documentation. Another issue is AI generated advertisements and chatbot utilization. This is hot. If you utilize AI for your advertising or your intake, or you have a chat bot, there are a whole lot of disclaimers and precautions that you will need to take. Here's the biggest one: hallucinated citations. You've read all the cases, you've seen the news articles, but lawyers are essentially, like I said, oftentimes because they're doing it at the last minute, generating briefs with hallucinated citations. Courts are finding out, opposing counsel is finding out. These are going to the state bar. They are going to special masters. They are going to judges for sanctions. There are candor to the tribunal considerations. There are client transparency considerations. I've seen the sanctions get up into the 7 figures already, or the consequences plus sanctions, monetary consequences plus sanctions get up into the 7 figures. Couple of other, things here that I wanted to mention. There's a whole new discussion about AI forged evidence in the courtroom and how to detect that. There's the question of how you as a supervisor, maybe somebody, like me who's been around for a while, how do we supervise the young people who are utilizing the AI when they know it perhaps even better than we do? And what internal protocols and AI training do you have in your firm? Do your protocols say that they can only use approved firm tools? Are your protocols practical? So that's a really high level overview. We're out of time. Howard, that was my last slide. I want to thank you so much for having me today.
Thank you. One comment on that. I think people should treat AI like any first-year associate whose work you would always be reviewing. A lot of lawyers I know, my attitude is I get citations from people working with me. If they're key citations, I always check them myself, especially if you're going to be the one standing in front of that judge. Just treat AI as if it's a first-year associate and you're going to review their work. And that's really the way to look at it, because these days, who knows what AI is turning out anyway. But Heather, that was fantastic. There a lot of information in a short period of time, and always wonderful to get a chance to see you and especially partake in everything that you're doing in your career. Thank you.
Thank you for having me, Howard. Thank you, everybody. Have a great rest of your week.